another mechanism through which activists and lawyers are contributing to legalism, and that is kind of testing the laws and showing where they have loopholes. So I mentioned that there are exemptions from the regulations about the accessibility of facilities. The 편의시설법 required only places that were 300 square meters or larger to be accessible until 2022. The lawyers and disabled persons organizations realized that cafes, convenience stores, hotels were all exempt from those regulations and therefore often inaccessible. So they got together in 2018 with just 4 plaintiffs and about 20 lawyers, and they filed a lawsuit against Chilla Hotel, Tusum Cafe, and GS25, the 3 largest in each of those sectors. That lawsuit was challenging the enforcement decree of the Convenient Facilities Act. Even though Korea signed on to the Convention on the Rights of Persons with Disabilities in 2007 and had this law prohibiting disability discrimination since 2007, it still did not revise that enforcement decree. And so the lawsuit was about legislative negligence or inaction for 24 years. It had not been revised. And really interesting, last December, some other things were happening, but the Supreme Court ruled for the very first time a case that the legislative branch had failed to act, and that was unconstitutional and illegal. They not only won this case, but the plaintiffs also got compensation from this case. It obviously did not get a lot of news coverage because of martial law and other things that were going on, but it's a really significant ruling. Again, the first time that the court found legislative inaction to have been illegal.